Good morning and welcome, everyone. Thank you for tuning in to another webinar from the New Lines Institute. My name is Emily Prey, and I'm a senior analyst for special initiatives here at New Lines. Today's event is brought to you by New Lines Gender Policy Project. As a part of our webinar series, I'm delighted to be speaking with Frady Rees and Nick Surratt on child marriage in the US. Frady Rees is the founder and executive director of Unchained at Last. Frady was 19 when her family arranged for her to marry a man who turned out to be violent. But with no education or job in an insular religious community where only men have the right to grant a divorce, she felt trapped. Still trapped at age 27, Frady defied her husband and community to become the first person in her family to go to college. She graduated from Rutgers University at age 32 as valedictorian. Her family declared her dead, but Frady persevered. With her journalism degree, she was hired as a reporter for the Asbury Park Press in New Jersey, eventually getting promoted to the paper's elite investigative reporting team. She went on to a career as an investigator at Kroll, the world's largest investigations firm. At the same time, Frady managed to get divorced, win full custody of her two daughters, and get a final restraining order against her ex-husband. But Frady knows that most women and girls who want to flee or resist an arranged or forced marriage are limited by finances, religious law, and social customs. For them, Frady founded and now leads Unchained at Last. Frady is recognized internationally as an expert on forced and child marriage in the US. Her writing on the subject has been published in the New York Times, Washington Post, and countless other publications in the US and beyond, and she has been interviewed and featured by those outlets, as well as the Financial Times, BBC, PBS, NPR, CBS, and others. Legislation she helped to write to end or reduce child marriage has been introduced and in some cases already passed in multiple US states. Nicholas L. Surratt is professor and chair of the Department of Women, Gender, and Sexuality Studies at the University of Kansas. A historian of the 19th and 20th century United States, he has written on the history of age, queer sexuality, sexual assault, masculinity, and marriage. He is the author of 3 books, including American Child Bride, A History of Minors and Marriage in the United States, and is the president-elect of the Society for the History of Children and Youth. His op-eds have appeared in the Washington Post, the New York Times, the Daily Beast, and others. Thank you both so much for joining me. It's an absolute pleasure to have you here, and I'm so excited to moderate what is sure to be an insightful and important conversation. Each speaker will have 10 minutes for opening remarks, after which we'll open it up for question and answer. And I'd like to encourage the audience to ask questions using the Q&A function at the bottom of your Zoom screen or the comment section on YouTube. And you can follow us on Twitter at NewLinesINST or subscribe to our YouTube channel. And this is also being recorded and will be available to watch on YouTube afterwards. So without further ado, Nick, the floor is yours for your opening remarks.
Thank you. Thank you, Emily, for inviting me to participate in this panel. I'm looking forward to the discussion, which is always good when Frady and I are able to talk together. So I am a historian, as Emily said. I'm going to give a little background on the legal history of children marrying in the United States and its earlier colonies, and the hope is that that'll set us up to figure out why we have the laws that we have now. And in order to do that, I am going to attempt to share my screen now. Okay. Okay. So in colonial America, the age of marriage was first regulated by English common law in the English settlements and by the Catholic Church in French and Spanish settlements. The minimum marriage ages in English settlements was 12 for girls and 14 for boys. And the Catholic Church set those ages 1 year lower at 11 for girls and 13 for boys. These were, at least in theory, pegs to when it was presumed that girls and boys would have reached puberty. While English common law said nothing about parental permission to marry below certain ages, many colonies did pass statutes related to consent. Broadly speaking, a New England colony said that minors below certain ages, usually 21 for boys and 18 or 21 for girls, required parental consent to marry. And then the common law ages of 12 and 14 thus served as the minimum. Some statutes used no ages at all and simply said that minors could not marry or that girls could not marry without their father's permission. And there were two main reasons that some of these statutes did not mention age explicitly. First, many people didn't know how old they were in an era before birth certificates and before age was a meaningful part of individual identity. And second, and this is perhaps the more important part, these statutes were never about protecting young people. They were about protecting parents and masters' interests in the property of their young people who served them as workers. By the time of the founding of the United States, some patterns had emerged about how different states regulated minor marriage. In New England, it was common for states to simply say that minors required parental permission, so a continuation of the colonial statute. This meant that those below 21, the age of majority under common law, required consent from parents. A girl above 12 and a boy above 14 could marry with that permission. Those were the common law minimums. By contrast, newer states, especially in the Midwest, were more likely to adopt two different age requirements, a pair of minimums, say 14 and 16, 15 and 17, and a pair of ages below which children needed permission, say 18 for girls and 21 for boys. What those states were saying, in effect, was that parents had the final say about whether their children could marry and leave their natal homes, but even parents should not consent to marriages below certain ages. So there's more of a recognition here that below a certain age is bad for the child, him or herself. The southern states were a mixture. The older ones were more like New England in allowing very young children to marry, and the newer ones were more like the Midwest. From the early 19th century, then, there is precedent for the kind of law that many states have now, where there's an absolute minimum age and also an age below which children need at least someone's permission. What is also noteworthy is that in almost all colonies and later states, girls could marry before boys. And here I'm just showing you among the earliest published rates of minor marriage that we have access to. These come from the mid-19th century from 4 different states and show that marrying below the age of 20 was not at all unusual and clearly much more common in the South and among girls rather than boys. The logic for having a lower age for girls was threefold. Parents often wanted to keep their sons at home longer because they were more economically valuable. Sons would also be expected to support any wife they married, and it was unlikely they could do so at young ages. And finally, the requirements of marriage placed upon wives were not economic, unlike husbands. So long as they were past puberty and were capable of keeping a house, girls were perceived as being capable of being wives. While minor marriage was never statistically the norm in earlier eras, it was also the case that early Americans did not usually measure one another by a chronological age, and that led the practice of minor marriage to be relatively unremarkable, especially in sparsely settled areas where men predominated, which drove girls' age of marriage down. Over the course of the 19th century, most states began the slow process of raising their minimum marriageable age or instituting such ages if they didn't already have them. This was a result of changing attitudes toward children and childhood itself. As middle-class families had fewer children over that century, going from an average of 7 in 1800 to 3.5 in 1900, they came to value children themselves differently. No longer were they relied on for their economic value. Instead, they were emotionally valuable and in need of protection. Over the course of the century, increasing numbers of kids also began to be schooled, which made everyone more cognizant of the importance of chronological age as a marker of identity. Very gradually, a practice that was once commonplace, adolescent marriage, began to seem unusual. The same impulse that guided efforts to limit children marrying, for instance, also led to the passage of child labor laws and mandatory schooling, age of consent to sex laws as well. But there remained hundreds of thousands of minors getting married well into the 20th century, primarily among the working poor in both rural and urban America. Many did so through perfectly legal channels, either because they lived in a state with low minimum ages, or they had their parents' permission, or they evaded their own state law by going to a state with a lower minimum marriage age, what some called migratory marriage. Many thousands also broke the law and married illegally, either by lying to county clerks or forging consent or writing away for marriage licenses so they would not have to appear in person. In an era before birth certificates were widespread, getting married illegally was both easy and common. So easy that many states tried to prevent it by passing laws that penalized county clerks who issued licenses to those who did not qualify. And no matter how many laws a person broke in order to get married, most judges held that the couple remained legally wed. The precedent for this was an 1854 case from Massachusetts called Parton v. Hervey, in which a 19-year-old and a 14-year-old were married without parental consent. Both were minors under Massachusetts law, but the judge held that because they were both above the common law ages of 12 and 14, and they had obtained a license to marry and been married in a legal ceremony, he was unable to make them unmarried. In part, this was a matter of public policy. No one wanted young, single, non-virginal, perhaps pregnant girls. And no one wanted it to be easier for ne'er-do-well men to seduce girls into marriage and then have the unions annulled. All of this is to say that no matter what the law said about how old one needed to be in order to marry in your state, there were other ways into marriage, all of which resulted in exactly the same legal version of marriage that everyone else had, with the same rights and responsibilities. Aside from a sharp increase in minor marriage during the 1950s, during the baby boom, when the average age of first marriage in the US was at the lowest point of the entire 20th century, the incidence of minor marriage has been on a steady decline. Changing laws reflect this as well, and I would argue that the laws in the later 20th century mostly reflect what was already happening, which was that almost all people were getting married at later ages, not earlier. Some weren't getting married at all. By the 1970s, almost all states had equalized their laws so that girls and boys no longer had differing minimum or parental consent ages. In almost all states, the ability to choose marriage without anyone's consent is 18, which by the 1970s had also become the age of majority in almost all states as well. That said, in all but the 5 states that have recently changed their laws, what developed was an increasingly complicated set of contingent laws that allowed minors to marry below the age of 18, but only if they gained the permission not just of parents, but of some judge or court as well. Others explicitly make exceptions if a prospective bride is pregnant. The laws, as we have them now, are a result of a clash between legislators who believe on the whole that minors don't need to be married, so that's why 18 is still the normative age below which you would need consent. Prior to the mid-20th century, anyone below 18 who wanted to get married would easily have been able to do so illegally. But in an era where almost all of us can document our birth dates, and where state laws are increasingly similar in terms of marriage ages, there are fewer ways to work around them. That's partially what produced all of these exceptions to the rule, ever more arcane laws to try to deal with every possible contingency. The laws are also clearly a reflection of some conservative lawmakers' worries about illegitimate pregnancy. And some of these exception laws do date from an era when being born a quote unquote bastard was not just a social stigma, but could also mean different treatment under the law for illegitimate children. That's no longer the case. Some lawmakers also feel that not allowing at least some minors to marry infringes upon the rights of parents to make choices about the best interests of their children. And while I can find no evidence that anyone worried about abortion at the time that the various exception laws were passed, indeed in most cases those laws were passed when abortion was illegal in many states, it is a worry expressed by conservative lawmakers today, despite the fact that no one has shown that pregnant teenage girls necessarily see their decision as being between terminating a pregnancy or marrying the father, or that limiting marriage to adults only leads to more abortions. There's no evidence. What unites conservative objections to a hard line around the age of 18, I would argue, is the belief that marriage is necessarily safe and protective of girls' interests. When conservatives say that a girl would be better off married, they are clinging to an ideal of marriage that often bears little relationship to the very particular circumstances in which married girls find themselves. And that's usually the case even for marriages that appear to be non-coercive and entered into willingly by minors. However, as you'll now hear from Brady Reese, there's a good deal of evidence that many minors are either forced or coerced into marriage by parents and spouses. This is clearly a far cry from the idealized marriage propagated by conservative lawmakers. So I will turn it over to Brady now, and I will stop sharing my screen.
Well, thank you, Nick. It's always, we're at Unchained at Last, so focused on the current laws in the United States and changing them. And it's always interesting to get the historical perspective and see how long this has been going on, basically forever. So But I always like to say the 1800s have called and they want their laws back. So let me share with you a story that has a sad beginning and it has an upsetting middle, but it does have a very hopeful ending. And this story starts with a forced marriage, my own forced marriage. I grew up in New York City, but I grew up in a very insular religious community where unfortunately forced marriage under the guise of so-called arranged marriage remains the norm. And my family married me off when I was 19 to a stranger with very little input from me. And unfortunately, the stranger turned out to be violent, which I discovered only 1 week after my wedding. But because of religious laws and social customs, I was completely trapped within this religious community. I had, first of all, no sexual or reproductive rights. I was required to have unprotected sex with my husband. So my first child was born 11 months after my wedding. Pretty soon I had 2 children. I had no financial rights within that community. Any money I earned, if he would have allowed me to work, would have belonged to him. I was not allowed to have my own bank account or credit card. And I also had limited legal rights in that community. A man is allowed to divorce his wife, but a woman does not have the right to divorce her husband. I finally managed to escape after 12 years in this abusive marriage with my 2 daughters, but my family and community retaliated against me. As you heard from Emily, they declared me dead. They shunned me and still, more than 16 years later, consider me dead. But I rebuilt my life with my 2 daughters, and I founded Unchained at Last, which is the only organization that is dedicated to ending. At first, it started with forced marriage in the United States. And at first, it started with specifically direct services, helping individuals to escape forced marriages. And a forced marriage is one in which one or both parties do not give full, free consent. And in many cases, the perpetrators are the parents who use different forms of force, fraud, coercion, pressure to marry somebody off without their full and free consent. And we provide really comprehensive, crucial, often life-saving wraparound services to help people not only escape their bad situation, but also rebuild their lives. And we've been able to help more than 700 individuals so far in this way. Mostly they were women, also LGBTQ individuals whose parents were using marriage as a form of conversion therapy. So it felt really great being able to turn my own trauma into a force for good and being able to help other people going through what I was once trapped in, that nightmare. Perhaps nothing as healing and empowering as that. But I did warn you that the story had an upsetting middle. And here's where it comes in. More and more girls under age 18 started reaching out to us at Unchained at Last to beg for the same crucial help that we were providing to adults. And we realized that there was almost nothing we could do for them because of their limited legal rights before they turn 18. And that's how we first came to realize that the United States has not only a forced marriage problem, but also a child marriage problem. And a child marriage is one in which one or both parties is under the age of 18 or the age of adulthood at the point of entry into that marriage. And at the time when this first started happening for us at Unchained at Last, it was about 2015, child marriage was legal in all 50 US states. And in fact, most US states did not, as Nick was saying, did not specify any minimum age for marriage. So technically the marriage of a toddler would be legal in those states. And at first, nobody really knew how often this was happening in the United States. We knew that the laws were really, needed to be updated and were dating back to the 1800s in allowing children to marry at any age. But in terms of how frequently it was happening, there was no research that was done on it. And we at Unchained at Last changed that. We, in fact, just released a groundbreaking study a couple of months ago that showed that between 2000 and 2018, nearly 300,000 children were married in the United States. A few of them were as young as 10, because that remains legal in many states, although most of them, 96%, were age 16 or 17. And a vast majority of them were girls married to adult men with an average age difference of 4 years. There are many reasons that we can discuss about why we need to end child marriage, but I want to focus on the 3 main ones. The first one is the reason that I'm so passionate about this personally as a forced marriage survivor. Child marriage can too easily be forced, and that's because children do not have the rights of adulthood until the day they turn 18. So something as basic, for example, as leaving home to escape from parents who are planning an unwanted wedding for them, or to escape from an abusive spouse, children typically do not have the right to do that. We've worked with survivors who escape from an abusive spouse before the age of 18, only to have the police drag them back home, bring them back to their abusive spouse. Getting into a domestic violence shelter. Typically, after we help the survivors to escape, the ones who are adults, safest place for them is a domestic violence shelter. Domestic violence shelters across the US typically will turn away unaccompanied minors. Retaining an attorney. You would want an attorney if you were in this situation to help you figure all this out, but contracts with children, including retainer agreements, typically are avoidable. Attorneys typically do not want to take on a child as a client. And then perhaps most devastating is children typically are not allowed to bring a legal action in their own name, which means in many cases, they're not even allowed to file for divorce. They can be entered into a marriage by their parent. Perhaps there's a judge involved, completely disempowered throughout that process. And then, like I was when I was trapped in my marriage under religious law, under civil law, not even allowed to file for divorce. So really what marriage before the age of 18 does is it creates a nightmarish legal trap for minors. Second really important reason to end child marriage, it just happens to be a human rights abuse. That's what the US State Department calls marriage before 18. It destroys almost every aspect of an American girl or woman's life, her health, her education, her economic opportunities, even her safety. It makes her much more likely to be physically assaulted by her spouse. And then the third reason is it undermines our statutory rape laws. Part of what our study looked at when we discovered that nearly 300,000 children were married recently in the United States was we looked at how many of those cases was the child married at an age or with the spousal age difference that should have been considered a sex crime. And the answer was 60,000. There are tens of thousands of children who are marrying right now in the United States before they're even old enough to consent to sex. So we at Unchained at Last jumped into action. We realized there's a really simple legislative solution here. All we have to do is let legislators know what's happening. They just don't know, we figured. And we let them know that most of them already set the marriage age at 18. It's these loopholes, dangerous legal loopholes in the law that Nick was describing, where you can marry if you have parental consent, or if you're pregnant, or if a judge approves. It's these legal loopholes under which hundreds of thousands of children are marrying and being subjected to a human rights abuse. All we have to do is show them they just eliminate the loopholes, keep the marriage age at 18, solve the problem, go home happy. And so we started writing op-ed articles, and we invented a form of protest called the chain-in, where we wear bridal gowns and chains to show this is what life looks like for somebody who's forced to marry. And we really at first thought that legislators would give us a hug and a high five, and this would be the end of the day. And, Nick, you're laughing now. You weren't there at the time. It seemed very reasonable. And yet in state after state, legislators looked at this simple common sense legislation that would harm no one, cost nothing, and save children, primarily girls, from a human rights abuse, and said, pass. And their number one reason, again, as you heard from Nick, was that pregnant teenage girl. They just, this determination of, I'm just an old fashioned kind of guy. I still believe if a girl gets pregnant, she has to get married, even if she was raped. And even those studies show that a pregnant teenage girl in the United States who marries is more likely to suffer economic deprivation and instability than a pregnant teenage girl who stays single. Well, we at all, just were so frustrated at a certain point at Unchained at Last because nobody was listening to us. In this moment of sheer frustration, we all promised that when the first US state finally ended child marriage, we would all get tattoos to commemorate the victory. And that is why I have this broken chain tattoo on my right wrist, because in 2018, Delaware, which was the first state, also became the first state to end child marriage, followed by New Jersey that same year. And then during the pandemic, whenever we were all locked down, Minnesota and Pennsylvania both voted unanimously. The legislatures voted unanimously and remotely to end child marriage. And then just about a month ago, Rhode Island ended child marriage. And in New York, the bill has passed out of the legislature. It's waiting for the governor's signature. So right now, we have also bills pending in multiple other states, by the way. And here's where we come to the hopeful ending that I did promise you. We now have a national movement to end child marriage in the United States. And we are now 5 down, 45 to go. If Governor Cuomo comes through for us, we'll be 6 down, only 44 to go in the push to end child marriage in the United States. And then, of course, we have to come back for the bigger picture of forced marriage of adults as well. But here's what I want to leave you with. There are some social injustices that we all agree are horrific, but there's no simple solution. We're not sure we'll be able to solve them in our lifetime. Child marriage has a simple solution. Not only can we end child marriage in the United States in our lifetime, we can end it this year if we all band together and insist that our legislators take action, simple, common sense action that, again, harms no one, costs nothing, and ends a human rights abuse. So we at Unchained at Last are going to keep chaining in and making noise and pushing until that happens. And we hope that every one of you will join us and make sure that we end child marriage and then forced marriage in the United States, because the 1800s are long over.
Thank you so much, Frady, for those powerful remarks. And thank you, Nick, for setting up the historical context that we need to kind of understand how we got to where we are today. So my first question is for Nick. As you both said, at the moment, child marriage is a state issue. And that can make ending the practice quite difficult because you have to go state by state by state. And it just, that's a lot of states to get through. Should we leave this up to the states, or should the minimum age of marriage become a federal issue? And if so, how would this happen? And do you foresee this happening anytime in the near future?
So to take us back a little bit, this definitely has been discussed by activists before. In the 1920s, really late 19th century onwards, there were a group of activists who were mostly concerned about divorce laws and easy access to divorce, but they did think about the minimum age to marriage. So what they believed would be necessary was both a constitutional amendment that allowed the federal government to regulate marriage, and then you would pass a bill that would be whatever ideal bill you wanted about who could get married and who could get divorced. It was introduced into Congress 35, 40 times, and it never went anywhere. So this is the real difficulty here, is that the way that federalism works, at least in the case of marriage, is that states have the right to regulate marriage. So I think you would have to convince a number of legislators to give up the state-held right to regulate marriage, and then you would have to get them to agree on what the overall marriage age should be. And I think that would be the difficulty. There have been a number of instances in recent years where marriage has been regulated at the federal level. So one would be the Defense of Marriage Act, which in essence basically said that no state had to abide by the full faith and credit clause and recognize the marriage of a same-sex marriage, or recognize a same-sex marriage conducted in another state. Obviously, the Supreme Court has fairly recently found that to be unconstitutional. So I think that the odds of getting lawmakers both to agree that they have the right to make this a federal issue, and then additionally getting them all to agree on what the actual age of marriage should be, make Frady's plan the more viable plan at this point. But Frady, clearly thinks that because she's doing it, but might also have other things to say about this question.
Yeah, no, I agree. So we always say we could try the federal approach, but we would get so stuck in a federalism debate and possibly a civil war, because we have fought a civil war over this issue. So it just doesn't seem to make sense to get bogged down in that. But there are laws at the federal level that need to be passed also to end child marriage in the United States. So while we are working state by state to change the marriage age, since right now it has been fairly well established that marriage age is set by each state and not by the federal government, we are pushing for federal legislation to close. There are some federal laws still in place that allow and even encourage child marriage. And we've identified 2 of them, but what we want is for Congress to investigate other laws and policies that are in place that allow and encourage child marriage, and then to change them. The 2 that we have found so far are, there is no, under federal immigration law, there is no minimum age to petition for a foreign spouse or fiance, or to be the beneficiary of a spousal or fiance visa. And what that does is it encourages the trafficking of children in the United States. It's usually girls who are forced to marry adult men overseas so that the men can get a visa and a path to citizenship. And also girls being brought to the United States under the guise of marriage, trafficked here, and then as a spouse, so that they can be legally raped, because unfortunately in most states what would otherwise be considered statutory rape becomes legal within marriage. And then the other one that we've identified is under the federal criminal code, sex with a 12 to 15-year-old is a crime unless you first marry the child. So that's, again, it's encouraging child marriage and child rape. So those are two examples, and I'm sure that there are others that we have not yet identified.
So Frady, you've worked incredibly hard on passing legislation, as you said, to end or to reduce child marriage in different states. And one would think that this would be a bipartisan issue. As you said in the beginning, you thought that it was just a matter of legislators not knowing, and once you let them know, they would fix the problem. It just seems so obvious on face value. How difficult is the work that you do trying to get lawmakers to end child marriage in their states and to stop making that excuse that you both mentioned, especially, when it's relating to teenage pregnancies, that girls are safer in marriage than they are by themselves?
Yeah, and that's just one of the many ridiculous, excuses. We call them, at Unchained LS, we call them vomitocious excuses that legislators use. We actually have turned that into a hashtag, and we have vomitocious Wednesdays. If you follow us on Twitter, every Wednesday you'll get some of the vomitocious excuses that we have heard. But to give you a sense of how difficult it has been, we started pushing for legislation in every US state to end child marriage. We started pushing in 2015. And 6 years later, 5 states so far have passed this legislation. We had in one state, New Jersey, which would have been the first state to end child marriage, the governor, then Governor Christie, actually vetoed the bill once it passed with a veto-proof majority. He still vetoed the bill because that's how adamant he was that we are not going to protect our children from a human rights abuse. I mean, it is obnoxiously and ridiculously difficult to answer your question. And, and Nick, I know you can talk also about some of the vomitocious excuses. I mean, Nick and I have been on panels where even other panelists will start raising, I call it the hypothetical Heather, and her situation gets ever more hysterical and dire. And somehow in these people's heads, as they're putting forward, the only possible solution is marriage. So she's being abused and raped, and she's pregnant, but she's also in love, even though she was raped, and it's just like the difficulties start compounding. And somehow also always someone's in the military, usually the guy who got her pregnant, who is both her staunch life partner, but also the guy who raped her. And I mean, it just gets insane. I mean, Nick, I'm not exaggerating, right?
Yeah, I think one of the things also that I've been surprised by, and Frady has more experience, so she's probably not surprised anymore, but so most of the objections or in what I have seen, a number of the more organized objections and that make their way, especially to the legislature, do come from conservatives who are worried about the pregnant teenager or who just have an outsized faith in marriage. But there are those on the, generally speaking, the left, or who would approach this from what they would characterize as sort of feminist reasons for objecting to it. And the two that I've heard most, that again, I don't find particularly persuasive, are one, that marriage is one way that a foster child in a bad foster care situation would be able to exit the foster care situation, to which I say, let's reform our foster care laws so that there are other ways to get out of abusive foster homes. And then some proponents for reproductive rights, which Frady and I both, of course, very much endorse, say that in essence, the right to marriage when pregnant or when sexually active is a reproductive right. I don't find this a particularly convincing argument, in part because of Frady's reasons. The number one reason is we don't know how marriages are going to work out once people enter them. And a 17-year-old is not yet an adult, and if she's trapped in a marriage, even if for the reproductive right of getting into that marriage, we don't know what's going to happen and she can't get out of it. So it doesn't hold water for me. But those are the two that were more surprising to me. I was not at all surprised by the more conservative ones, because those are the ones that have been used for most of the history that I have studied as well.
Mm-hmm. Yeah, I mean, look, and this is, to follow up on what Nick was saying, this is not a question of bodily autonomy. You can have sex, have a baby, have an abortion, regardless of your marital status. So we're not saying you can't be in love. We're not saying you can't have a baby. We're not saying you can't co-parent. All of those in the year 2021 are legal to do outside of marriage. And, and along those lines, another one that we have gotten as pushback from the more feminist crowd and those who care about girls' rights and reproductive rights is, if we tell girls you can't get married, does that mean next we're going to tell them you can't have an abortion? Is it going to undermine reproductive rights? And that's, of course, that's absolutely not a legitimate concern. First of all, the US Supreme Court has weighed in on this. And in Bellotti v. Baird, the US Supreme Court said that states should treat minors' abortion differently from minors' marriage because abortion is time sensitive in a way that marriage is not. You can tell a 16 or 17-year-old girl, wait until you're 18 to marry, and you did not deny her the right to marry, you simply delayed it. The day she turns 18, she can have a big, beautiful wedding, she can invite me. You cannot tell a 16 or 17-year-old girl, wait until you're 18 to have an abortion, then you have effectively denied her the right to that abortion. So because we're talking about the difference between abortion and marriage is that one is time sensitive, the other is not. And also one is a medical procedure where rights of adulthood to undergo a medical procedure, not crucial. You can undergo a medical procedure before you have the rights of adulthood versus a legal contract. Having legal rights of adulthood, that's crucial before you enter into a contract because you can't safely navigate a contract if you can't retain an attorney or get out of that contract. So because these are so vastly different, that is also not a concern. I've heard every possible argument for why there should be some loophole or exception where children should be married. And I have been able to refute every single one. There is never, ever, ever a situation where a child should be subjected to a human rights abuse. There is absolutely never, ever that situation. There's like with other human rights abuses, we don't end it unless an asterisk and wink, wink, it's done, finished, let's move on.
Nick, do you think that international law and treaties can protect children in the US if our own laws aren't doing the work right now? Because at the moment, the US is infamously, I believe, one of 2 or 3 countries, or maybe the only one at this point, who has not signed on to CEDAW, to protect violence against women from violence, or the Convention on the Rights of the Child, because apparently somehow signing on to the CRC would weaken our own child protection laws here. So do you think if the US were to sign on to these treaties, or would that have any effect, or could international law be used at all here?
It's a great question. And I am not an international lawyer, so I can speculate, but I don't know. And my speculation, I think it's fairly well established that the reason the United States doesn't want to sign on to these is because they don't want the oversight. They don't believe that they should subject themselves to the oversight by other nations, that that's not something the United States needs to do. So in one way, symbolically, I think it might be helpful. That is, if they were to sign on and still be in clear violation of the dictates of the laws, I think symbolically that could be helpful. But we also know that lots of other nations have signed on to the Convention on the Rights of the Child and CEDAW and regularly violate the dictates of those as well. So I'm not sure that in a practical matter, it would necessarily change all that much. But I do think it's noteworthy that the United States so consciously has chosen not to do this. And it may well be related not just to this issue, but to other issues that it knows that it is not doing what it should be to protect both women and children in the ways that it should.
Mm-hmm. Yeah, and I agree. I don't think that would make much of a difference. Also, neither CRC nor CEDAW is especially strong on child marriage. The language in both of those is not exactly what I would have wanted to see, but it is offensive that we haven't ratified those. But there are promises that we have made to the world. For example, the United Nations Sustainable Development Goals. So Sustainable Development Goal 5, which the United States was among the 193 countries that signed on to the United Nations Sustainable Development Goals in 2015. And Sustainable Development Goal 5 calls for achieving gender equality. And under that, target 5.3 specifically calls for the elimination of female genital mutilation, as well as child early and forced marriage, because both of those are recognized as harmful practices that are hindering global progress toward gender equality. So even though the United States has signed on to that, it has not made much progress since 2015 toward eliminating child early and forced marriage. So I think, like Nick said, it would be more of a symbolic move. And unfortunately, it doesn't really seem like legislators here, especially state legislators, are particularly invested in keeping our global promises. And by the way, under the Sustainable Development Goals, we're supposed to do this by year 2030. We promised the world we were going to eliminate child marriage by year 2030. We're halfway through 2021, and 45 US states and the federal government still have not acted.
It doesn't seem likely that this will happen by 2030 at all. And it's incredibly disappointing.
No, but that's before allies, Unchained at Last and its allies, including Nick. I mean, we're pushing really hard. So, maybe the United States doesn't want to keep its promise, but there are those of us who are standing by, making a lot of noise and saying, we're not going to let this go quietly. So we still have a few years to go.
And thank you so much for your work. It's so incredibly important, and to have allies who are working on this issue as well. So for anyone who's watching, who are wondering what they can do to help to end child marriage, to reduce child marriage in their states, what can regular people do on this issue?
Well, first thing is go to unchainedatlast.org and sign up for the email list. We don't send a lot of emails. We send when we have something important to say, but educate yourself on the issue. Follow us on social media. We're on Facebook, Twitter, Instagram. We're just at Unchained at Last, and retweet our Vomitocious Wednesday excuses, and tell other people. Go tell everyone were you aware child marriage is still legal in most of the United States? So if you go to our website, it also has some specific ways that you can get involved. If you live in a state where legislation is pending, you can very easily, we have email campaigns where you can just put in your name and address, and it will send emails to your legislators letting them know that you believe strongly in ending child marriage and that you insist that they, as your elected representatives, do this. And even if you don't live in one of those states, there are some ways that you can get involved. There are some big ones and then some just really easy ones like following us on social media. But I always say it takes a village to end forced and child marriage. And I ask that everyone become a part of that village.
I also want to talk about the complicity of people who stand by watching while this happens, and not only stand by, but are actively participating in this, because as in your case, and as well in many other cases, parents are complicit and are actively a part of the problem in this. So when children have nowhere, they're supposed to turn to their parents for protection and for help. But when their parents are the ones putting them in a dangerous situation, where can children turn?
And that's a question not only for children, but also for adults. If there's one thing that unites the more than 700 survivors we have worked with at Unchained at Last, and my own personal story, for almost all of our cases, it was our own parents who did this to us. And the betrayal by parents is, first of all, just devastating emotionally, because these are the people who are supposed to love you and care about you, and they're the ones doing this to you. But it also makes escape incredibly difficult, because the people who normally would help you to escape instead are the perpetrators. So yeah, and in almost all the cases, especially when it involves children where there are, unfortunately, we don't have a lot of laws and policies in place to acknowledge forced marriage, to criminalize it, to punish it, to prevent it. And we don't have a lot of laws like that. And while we don't have laws, unfortunately, in most states against child marriage, we do have statutory rape laws. We do have child abuse laws. I mean, a lot of what's happening is against other laws. And we have so many people just standing by when there's a judge or a clerk who sees a pregnant girl showing up for a marriage license before she's old enough to consent to sex. There's only one way a girl who's too young to consent to sex can get pregnant, and that's if she was raped. Instead of handing out a marriage license, there should be a criminal investigation. So yeah, so we need upstanders. We need all the people, all the people in the system. And so many of the survivors that we work with talk about how after they were raped, they got kicked out of school because we can't have a pregnant girl at school. And then all the people who just continue to victimize and punish them. And we have so many times domestic violence shelters or other social service agencies that don't view forced marriage as a form of abuse. Why not? Why? How could you not recognize this? This is such an obvious form of domestic violence, forcing somebody to marry. And a forced marriage is just, I mean, not only is it itself an act of domestic violence, but it also means forced consummation. It means rape. It means a lifetime of rape, not only on the wedding night, it means a lifetime of rape. How could we not recognize this as the abuse that it is?
Yeah, I think it's incredibly important to highlight that. And also, I know that you've mentioned in past panels, but the laws against child marriage in the US are weaker than so many countries around the world. For example, in Afghanistan, some states in the US, including California, they have weaker child marriage laws than in Afghanistan, which I think would be shocking to some, to many. But once you actually begin looking at it, you can see that they're protecting children really has not been a priority in our country and in our state legislatures. So for Nick, yes, please go ahead.
I was just going to say one thing that sort of a historical tie, of course, that relates all of this is that if we think about when age of consent to sex laws or what we call statutory rape laws were passed, the intent wasn't. Legislators were rarely interested in the physical harms that might come to girls who had sex before they were whatever age it was. The real harm that they foresaw was reputational harm. And the fact that a girl would no longer be a virgin and still be single, she would never be able to marry. So these were laws that were meant to punish the man, but rarely were they framed in such a way that they were talking about, physiologically why this was harmful to a girl, which then I think if we trace forward 130 odd years to now, we can see how that's still playing out, that there is this belief that so long as the sex occurs, even if ex post facto within the confines of marriage, that it cannot actually be a problem, even if we see that the sex clearly predated the marriage in the first place. So among those who are complicit in this is not just the judge who issues the marriage license, but it's the prosecutor who chooses not to do anything about this because the solution to this is to make it right via the institution of marriage, which is both ignoring the law and also an outside space in what in the end is simply a set of laws and a license. It's not a guideline for proper behavior between two individuals, one of whom, as Brady pointed out, has already broken the law by having sex with the girl he is now proposing to legally wed.
What are some of the effects of child marriage, not just on the victim themselves, but also on the country or society as a whole?
I'll say one, and I think it's that, and it does stem in some ways from individuals, but I think that so long as we're allowing girls to get married and get trapped in these relationships that we know lead to, I mean, girls who get married are far less likely to graduate high school. They're far less likely to have all kinds of opportunities that would be available to girls who don't get married. We're setting ourselves up for the perpetuation of just more gender inequality. And if one of the things that I certainly as a feminist am trying to move towards is leveling the playing field for girls and for boys. And marriage traps girls. Girls don't have the same opportunities. And it is, in at least most of the evidence that I've seen, a lot of the time, this is also girls who are impoverished, who don't have a lot of opportunities to begin with. So they see marriage as something that they might do anyway, which is why everyone thinks it's fine for it to happen really early. But what we need to do is postpone that marriage so things like high school graduation, careers, college, and so forth can still happen. So it's, in some ways, it's part of a broader piece of gender inequality for sure.
Yeah, and so obviously gender inequality is like the most obvious one, but there's a financial cost to society as well, because Nick was talking about how in the United States, a girl who marries at or before 18 is much less likely to finish high school, also much less likely ever for the rest of her life to graduate from college, much more likely to also end up living in poverty in adulthood, also at a significantly increased risk of various health disorders because of the forfeited education and the poverty and the stress that come from a child marriage. So you can imagine a lot of them end up as needing assistance from the government in a way that they would not have if they would have just waited until 18 to marry. So there's a financial problem here as well. We should never end a human rights abuse only because of the financial impact, but there is, for those who don't give a crap about girls, do you at least care about the budget? I mean, we're also wasting a lot of money on this. So we're destroying lives and it's costing everybody money.
Moving forward, is there anything that either of you hope to see from the Biden administration on gender equality, child marriage, etc.?
I think it would be, given that we've already talked about the fact that we see this as something that is likely to be solved on a state-by-state level, with the exception of those two laws that Brady talked about. One, Biden could at the very least highlight it. I think it would be enormously powerful to have the sitting president acknowledge this as a problem in the United States, spurring state lawmakers on to do something, or to highlight it to Congress, the two laws that Brady talked about that are controlled at the federal level. So he could certainly do more than that, but simply an acknowledgement in a public forum would be an enormous boon, I think.
Yeah, and we want also the federal government to investigate other laws that need to be updated. And so certainly we're pushing for legislation and a resolution. Also, we're working with some federal legislators on introducing a resolution that reaffirms the United States commitment to United Nations Sustainable Development Goal 5.3. So there's that. But the Biden administration has announced the formation of the first ever Gender Policy Council. It's a reporting directly to the president, which is really a historic a council, but also an entirely new opportunity to get the president's attention on gender policy issues, including, obviously, we know that child marriage and forced marriage are much more likely to happen to girls. It's very much a gender violence issue. So we're working hard to make sure that the Gender Policy Council, once it's fully formed and up and operating, is going to keep child marriage and forced marriage on its agenda. And we're optimistic that it will, something that never could have happened under the previous administration.
No, certainly not. And hopefully, given Biden's past history working on violence against women, that's been one of his big issues throughout his career. So hopefully he will highlight child marriage or continue to work on this through his Gender Policy Council. As we're nearing to the end, I just want to ask if either of you have any final comments to make, anything that we didn't bring up that you want to make sure that we highlight right now.
Well, I just want to end with, again, at Unchained at Last, we are really committed to seeing a world where a girl is never again a bride, and where every adult is free to choose whether, when, and whom to marry, and whether to get divorced. That's not too much to ask. Let's do this.
I would say also, I think one of the things that Brady's campaign has done, and that our conversations like this have done, is to make Americans, I think, more aware that the version of child marriage that they believe that they're familiar with, one of the reasons that it's easy to overlook for some people what's going on here is sometimes the age of the children, but I think also it's our ideas about, sometimes sadly, racist perceptions of the backwardness of other countries that allow us to think that that's a problem that they have over there and not something that we need to worry about here. So I think frank and honest conversations about the problems with our own laws and acknowledging this problem is the only way we're going to move forward to fixing the problem.
Well, thank you both so much for joining me today. This has been a really wonderful and really wonderful conversation. I've learned a lot. And everyone, please follow Unchained at Last on Twitter. Please sign up for their newsletter, contact your legislatures. And thank you both so much again for joining me today, and have a good week.
Thank you.
Thank you for having us.